What state-specific contract laws apply to real estate wholesaling? Imagine trying to buy a house and then sell the rights to someone else without actually owning it. That's what real estate wholesaling is all about. But did you know that each state has its own rules about how you can do this legally? It's like each state has its own playbook for real estate deals. If you're thinking about jumping into wholesaling, knowing these rules can save you from costly mistakes. First, let's talk about contracts. No matter where you are, you need a solid written agreement that spells out who is involved, what property you're talking about, how much it costs, and when everything closes. When you assign your rights to buy a property to someone else, you use an assignment contract. This document should include a copy of the original purchase agreement and clearly state your assignment fee, which is how much you're earning for passing the deal along. Now, some states want you to have a real estate license if you're doing a lot of deals, or if your marketing looks like a licensed agent's. For example, in Arizona, Illinois, Oklahoma, and New York, you might need a license if you do more than one wholesale deal a year, or if you're actively marketing properties. Other states like Alabama, California, Colorado, and Florida do not requiring a license but still expect you to be honest and transparent about what you're doing. Disclosure is another big part. Many states want you to tell the seller upfront that you're not buying the property for yourself but are instead assigning your rights. California, for instance, requires clear disclosure of your role and intentions. Arizona recently made it a rule that you must tell both the seller and the buyer that you plan to assign the contract. Maryland asks for written proof of your assignment fee. States like Ohio, Alabama, and South Carolina also stress the importance of transparency to keep everyone protected. Marketing rules vary too. Some states restrict how you can advertise properties. You can't just put a property for sale without revealing that you're only selling your contract rights. Kansas, for example, says you can only market the contract, not the property itself. Pennsylvania and Michigan warn against using language that sounds like you're a real estate broker if you're not licensed. Some states even recognize different ways to do wholesaling, like using land installment contracts. These are agreements where the seller keeps legal title while the buyer gets equitable interest. South Carolina has updated laws about how these contracts work, especially when it comes to assigning rights. For Asian American real estate investors and wholesalers, understanding these state laws is key. Always use clear, written contracts that spell out everything. Be upfront about your fees and your role. Don't market properties directly unless you're licensed. Keep up with law changes, especially in states with recent updates like Arizona and Illinois. And consider working with a real estate attorney to make sure you're following all the rules. Doing this helps you stay legal and build your wealth through smart, ethical wholesaling practices.